We're going to add a bill to the agenda. It's House Bill 375 by Chairman Jay Powell. House Bill 375, Chairman Jay Powell. That bill will be on the agenda today. There was a mix-up on my part, but we're going to add that today. It'll be probably the third bill that's taken up today. With that, we'll go ahead and get started, and we'll start with Representative Setzler's 182. Thank you. Before that, let me go ahead and acknowledge Judge McGarity and Judge Boyette are here. Where are you? Hiding in the back. The judges always hide in the back. Thank you both for being here. We appreciate your being a continuing resource to the committee and to the House of Representatives. Chairman Setzler, we appreciate it. You didn't have to come to this. If you want to do it over there, you can too, whatever you're comfortable with. But the floor is yours.
Allows a rear tail light that's out. If that person is taken in and is arrested, that they be able to refuse, and that a warrant which leads to the forced blood draw, which again, as we can see, in some cases has led to folks being strapped down, multiple cases of people being strapped down to a gurney while they're restrained by law enforcement officials and blood's withdrawn. That policy, as a pure policy matter, is out of bounds of the policy decision that stands before this legislature. Would the courts allow that to happen? The courts really put that to us. The courts have neither prohibited it nor mandated it. But as the lawmaking body, as the policy-making body of this state, it's the contention of HB 182 that for a standard DUI, that a forced blood draw doesn't meet the standard of a reasonable search, and that we as a body would act very clearly to restore. But for those cases where a felony's in the balance, a forced blood draw wouldn't be available to law enforcement. So, Mr. Chairman, we can walk through the details of the bill, but we prepared some questions.
Well, as I understand it, it prohibits, or what the bill intends and seeks to do is to prohibit the forced blood draw in the absence of serious injuries or fatalities, and serious injuries are defined beginning on line 21. Is that essentially the bill?
That's correct.
Okay. Questions from members of the committee? Any questions from members of the committee for the author? Seeing none. Is there anyone who would like to briefly speak? Mr. Spehaus, on behalf of the Prosecuting Attorney's Council.
Yes, sir. Apologize. We must have missed this one getting added.
It was added this morning, and the electronic notice was sent. And usually we try to do 24 hours, but given the fact it came out of subcommittee late, and of course folks gone home and all that, so. But you know, the floor is yours. Sure.
If I could briefly speak on behalf, I know the
Absolutely.
Solicitor General's Association has taken a strong position on this. Let me just ask the committee members to consider this. What this does is obviously it narrows what is a practice now of an individual is stopped for whatever reason that justifies a stop, that probable cause is established to believe an individual is under the influence of alcohol, and that individual then refuses a state administered test. Now, the repercussions of the refusal operates in a administrative process involving the driver's license. But at this point, the officer has the ability right now to, like in any other criminal case, apply to a neutral and detached magistrate for a search warrant. Now, they have to establish probable cause in that search warrant to do it, and that court has to find that. If they order that, then, as in any other crime, the officer has the right to then withdraw that. Most of the time, that happens in a very, for at least cordial environment that can take place. There was obviously some stories that have been in the news that were graphic. There's no doubt about it. So here's the question you've got to decide, and this is the policy side of this. Is this General Assembly ready to say that you're not going to make available the understood and established doctrine of applying for and gaining a search warrant for evidence in a criminal case? And I know there'll be discussion about the intrusiveness into the body and that kind of thing. But what I am going to ask is, if you're to move forward in something like this, can we talk specifically for a moment about the provisions in the bill? And that is, it attempts to limit that search warrant when there is serious injury or death and a refusal. You say something about that. Prior to this provision in the law that this is tweaking, the reason it got tweaked was some case law that had taken place. And I remember when we came through here and had these conversations in this room with that committee then. And what took place there was you had situations where there's a serious injury or fatality, and the individual that you're seeking that from can't give consent because they're either unconscious or they are in the hospital. You can't get to them. They've now taken some sort of medication that's been given. They can't consent. And that what you're anticipating here is they would actually have to consent or refuse to consent before you can get to a search warrant, even in serious injury and fatality. So we say that's problematic. And the second thing that the solicitors have discussed is you've now got a culture of refusal. The number of refusal cases are substantially higher now than they were even 3 and 4 years ago. We ask you to consider the concept of the repeat DUI offender. While this is often painted a picture about the first time DUI offender stopped at a road check, an officer smells alcohol, establishes probable cause, gets this search warrant, holds them down and takes blood, and that's the evil that we're trying to remedy. I submit to you to seriously consider the concept of what about that offender that has been previously convicted of DUI and then gets back out in conscious disregard of everybody's safety and continues to do that. And what they learned from that first DUI conviction is not to take the test. I ask you to seriously consider, if you're going to create this categories of when a search warrant would be available, that individual that's got that prior DUI conviction and is now before the court on a second or subsequent and probable causes exist, that you should seriously consider letting this remedy be available as well, or this investigative tool be there too. So I'll take any questions.
Questions for Mr. Spayhouse? From a logistical, I understand what you're saying, because you're talking about the offender, the repeat offender, who's knows the system and can go ahead and perhaps game it. But how do you delineate that? I mean, how can you logistically deal with that right at the time of the stop?
Legitimate question. One thing technology's done for law enforcement is made a lot more information readily available. Now, not every police car in the state of Georgia is equipped with a laptop and instant access to GCIC, but most are. But even in my day, in the 90s, I could still, with name and date of birth on the side of the road, run a criminal history through my dispatch, and they can do it in a GCIC terminal attached to their dispatch, and instantly have access to that information to know that there's a conviction showing. And keep in mind, it would have to show what we're submitting to you, that there is a conviction on the record for DUI.
So if you've had one or two, just hypothetically, one or two DUIs, just to make sure I'm understanding your point completely. If you're a repeat offender, let's say, and if at the time of the stop, the officer has not yet approached the vehicle, let's say it's just a regular random traffic stop, they haven't approached the vehicle. What you're talking about is being able to verify whether there's a previous conviction before making the determination as to whether or not the officer will have the legal ability to get the warrant and do the forced blood draw.
Yes, sir. Practically the way
can we do that? I mean, can you go? I mean,
practically this is the way it plays out. You stop a car for weaving or whatever it is. You now walk up to that car, investigate it, smell alcohol, see the manifestation, see the open container, hear the slurred speech, all of the things that happen in these cases. You go through this whole process, you make a determination at the field sobriety test that there is probable cause. You read implied consent, and they say, no, I'm not going to take it. At that point, they're already running the driver's history or driver's license to make sure it's valid. The same thing will take place. They'll run the criminal history right then and there and can tell the officer, yes, this individual has a prior DUI, and that's showing as a conviction on the record. That officer can then make that decision that a search warrant will be available. So you wouldn't get to that until probable cause has been made and there's been a refusal practically.
Do we have any larger, higher level issues? This is more of a rhetorical question for the committee. So we're going to go ahead. You can do a forced blood draw on someone if they have a repeat offender, but you can't do it on a first time.
Well, I can make the argument that individual.
I mean, do we have any constitutional issues with that about how certain procedures that might occur on a repeat offender as opposed to a first? Just thinking out loud and looking at counsel.
Well, compared to what you're proposing here, you are taking that same offender that's been stopped, and because of the result of those acts, you're going to treat it different.
Okay.
I'm saying the same thing applies. I mean, here's an offender, here's the facts, here's probable cause. You got to get to there before we even make this next step. Now what we're saying is the next step is, and there has to be serious injury or there has to be homicide. But I'm saying there can be a third. You have been previously convicted of DUI and you're back out there.
I wonder what kind of legal challenge that would initiate. But I
don't think it's any different than.
Okay. Well, Mr. Setzler.
Mr. Chairman, to speak to Mr. Spayhouse's issue and kind of to draw the distinction, I do think there's a fair distinction, and I think the government interest is much more clear when there's a felony charge hanging in the balance. You know, if we as a policy statement believe that in general a DUI, the difference between a DUI conviction, really what's in question is the likelihood of conviction with a breathalyzer test taken or with a forced blood draw, the information that comes from a forced blood draw versus the likelihood of conviction without a forced blood draw. I mean, convictions can still be obtained and often are obtained without forced blood draws. it's the point the government makes is we need the forced blood draw because our likelihood of conviction is going to be higher. Okay, but in general, we're making the policy statement that forced blood draw is out of bounds for a general DUI. The compelling interest in the case of vehicular homicide or serious injury by vehicle is that you've got a felony charge that when you boil the case down really will hinge on that BAC. And in those circumstances, the policy position of 182 is because of that, the government interest rises to a level where it's compelling enough to recognize forced blood draw as appropriate because an awful lot's hanging in the balance. In other circumstances, it's the difference between likelihood of conviction with a blood draw versus without a blood draw, and that distinction is, I think, unclear. And I think it's if we believe that a standard DUI stop shouldn't lead to a forced blood draw, that refusal should be the policy of the state, that one can refuse. And I believe it's certainly my belief that there should be the ability to have a refusal. This fully recognizes there's a very compelling government interest of the felonies in the balance. But otherwise, it's generally the policy position of the state that refusal still be available.
Mr. Coomer.
Thank you, Mr. Chairman. One of the reasons I agree with the chairman's with Representative Setzler's bill and the distinction it makes is because of how you get to these two different cases. When you have a standard DUI, if I can use that term, usually you have an officer who's observed something about the driving that leads him or her to make the stop and then do the investigative detention and then go through the arrest and ask for the consent. In Representative Setzler's bill, where you're addressing death or serious bodily injury, I'm imagining a situation where an officer rolls up on a scene that's already static. There's nobody driving around. There's already been a wreck. There's already, people are in a bad situation. So you're definitely going to have less evidence going into that case of a DUI because you're not going to know how the person was driving other than there was a wreck. So for me, it makes sense to draw the distinction here because of how you get to this point of arrest in the two different cases.
Thank you. Any further questions from Mr. Spejas? Mr. Grabbley.
Thank you, Mr. Chairman. To the gentleman's point down here, would there not also be a compelling interest to the state if an officer has made, as you said, the swerving of the driving, maybe crossing over a center line or whatnot, pulling the individual over, going up to the car, noticing maybe the smell of alcohol, seeing open container, and as that criminal history has been run, realizing that here we have a repeat offender, somebody who's already been, and you're not talking about somebody who's had maybe a previous DUI charge drop down to a reckless driving. We're talking about a conviction. So here we have a repeat offender who has made the second time choice to get out on the road. Now we've got a public safety issue. If we're going to do it for homicide, if we're going to do it for serious injury, the officer's just pulled somebody over whom, with a preponderance of evidence, suspects DUI. Once again, they have the right to refuse. But yet they also are now realizing we've got somebody who's been in this situation before and convicted of a DUI and allowing the forced blood draw in that second time situation. Would that not be a compelling interest to the state, if not for a public safety, from a public safety perspective?
Question for Mr. Spejas?
I think you just restated my argument. Rather flip.
Let me ask Mr. Setzler, do you have a question of Mr. Spejas?
I do not.
Okay. Any other questions for Mr. Spejas? Seeing none. Is there anyone else who'd like to be heard on House Bill 182?
Chairman,
Go on. Yes, sir.
I was another committee here. I didn't know if it was on the agenda. Can I speak real
Sure.
quickly?
Just let us know who you are.
For the record, I'm Matthew Kroll, I'm the Solicitor General from Douglas County, and many of you know me. You've heard from me last week and over the last several months about this bill and about this concept. And I just want to, from the Solicitor General standpoint, and Chairman Golick, I think you recognized this on October 10th of last year in Chairman Wright's study committee. We had a defense attorney come up, and he said, whenever I have a refusal, I can get an acquittal. When I have a refusal, I can have an acquittal. And I'm going to paraphrase what you said, Chairman Golick, is that you realize that system is broken and something you needed to revisit. And we had that conversation October 10th last year in Chairman Rice's subcommittee. And I think in dealing with this and flushing out with Chairman Setzler and his subcommittee, and we've had long conversations with him and Representative Hightower, Representative Gravely about this issue, I think the problem for the solicitors, and I think the problem for the legislators in the legislature, is that we have created a system of refusal where refusal is the ultimate problem. Refusal is hiding a ball. I think when we created this law, this implied consent law back in the late 60s after Schmerber v. California, I don't think that legislature or subsequent legislatures really realized what we were going to have when we have this culture of refusal. And that's where we are with this. It's not the problem that we're drawing blood. And I don't have a problem with saying you can't draw blood, but give me a way that I can get that evidence or make it disincentivize the fact that we want these individuals to refuse. They have an incentive right now to refuse. And the study that the Department of Public Safety has done on the ALS, when you refuse, you have to go to an ALS hearing in order to get your driver's license suspended. And the officer has to fill out a form. It's called a DPS 1205 form. He has to send it to the Department of Driver Services. They schedule a hearing with the Administrative Office of Courts, or I'm sorry, with the Office of State Administrative Hearings. The officer, then at that point, he has to show up to this hearing. DPS has done a study that the officer show-up rate is only 20% in these cases. So the problem is that there's no real incentive when you refuse. What's the punishment? There is no real punishment. And there's no incentive for this person not to refuse. And I think that's where we are. I want everyone to take the state breath test. I do. I really do. I don't want to have to stick needles in people's arms to get my evidence to prosecute this case. But if I don't have the evidence, I can't hold these people accountable in order to get them the rehabilitation they need for breaking the law. And I'd like to leave it at that.
I appreciate your comment. I mean, as far as I remember the study committee in the fall, and I think both Mr. Setzler and I were there. And, of course, Chairman Rice has a bill pending right now that we'll be taking up in the interim because it's got a lot of moving parts that seeks to reform that system. And that's something that's probably overdue. But respectfully, I mean, I think what I hear you saying is that, the ends, you're making an argument that's essentially the ends justify the means. And from your perspective, I understand that. And the reason why prosecutors are so important in the state, and part of the reason why we love them, is because they have a tunnel vision. And I would submit to you that sometimes our greatest strengths are also our greatest weaknesses. If we all looked within, I think we would privately admit that to ourselves.
I'll publicly admit it.
Yeah. And for those of us in public life, we have no choice because the people are already acutely aware of it, right? So I hear you. I understand. There may be a prevailing feeling on the committee that that's two separate issues. But we're going to find out. Mr. Coomer. Okay. Any questions for the... I'm sorry, Mr. Hightower. Okay. I see no questions.
Thank you.
Thank you.
Appreciate your time.
Appreciate you. Would anyone else like to be heard on House Bill 182? Seeing none, what's the pleasure of the committee? Mr. Coomer moves do pass HB 182 LC 296415S. Is there a second? Second by Mr. Setzler. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? Nay. In the opinion of the chair, the ayes have it, and the motion is adopted. We'll move on to, let me stand by for 1 second. Let me see if Chairman Willard is back. We'll suspend for about a minute.
He's coming back.
House Bill 72. Representative Willard, Chairman Willard.
And thank you, Chairman and members of the committee. I'm here on House Bill 72, and let me give you a little background. 2 years ago, we passed a bill that was identified as House Bill 78. That bill made a substantial change, and a lot of it was recodification, but changes in what we have as far as the laws in Georgia dealing with the abuse to elderly and disabled persons. And what you have before you is we'll call it a cleanup bill. It has some other provisions, but some things have come to light during the time that the previous bill 78 has been enacted and been operating. We've had good reports coming back from the Prosecuting Attorneys Council and the GBI of things that they have been able to use this law to help protect those who are the most vulnerable elderly in our state. And I'll go through briefly with you some of the items if you wish, and this is going by the various section numbers. Number one is really just clarifying a definition of disability, and number two is a venue provision that allows for venue involving crimes of elderly and disabled persons abused or exploitation, to lie within where the victim lives, as opposed to always having to go where the person is. This allows us to look at where the person itself is living, because you talk about people who are generally not able to get out and get about to court. Third is an area dealing with the RICO prosecution of criminal enterprises, and adds crimes under this law for elder protection statute to be listed to predicate acts for the purpose of the RICO prosecution. I'm going to leave this to our Director of the Prosecuting Attorney's Council to address in more detail for the committee, Mr. Chuck Spahos. Number four is the trial scheduling preference. It permits a court to grant a trial scheduling preference after a hearing in all cases involving the elderly or disabled. And this is, again, to be sure we can expedite these trials, because we're dealing with people who, by their age and condition, are somewhat vulnerable from a time standpoint, to be sure that they can get to court before perhaps further disability or demise. The number 5 includes investment in brokerage firms as mandatory reporters. It amends the definition of financial institution to include brokerage firms and other investment firms, making them mandatory reporters. This is important because we were asked by these organizations to include them, because many times you have people who have like a 401k and large investments of their retirements in those 401ks, and we find that if they're being abused, that's what the abuser is trying to get to, is money in their investment accounts, not just their bank account where they have a checking account or a savings account, but the actual investment. So the point is here, we're giving some protection to those people in reporting. If they feel that there is in fact potential abuse there, they can inform the local authorities for the purpose of doing an investigation without fear of having a lawsuit brought back against them just for the purpose of reporting. Number 6 defines the responsibility of mandatory reporters when reporting suspected abuse of elderly and disabled persons to law enforcement. Section 7 allows for evidence discovered during routine inspections to be used in criminal cases. This is where you have investigation or inspections rather being done by agencies of the state. That information can now be brought forward as part of the prosecution of the criminal case. And number 8 revokes the license to operate a personal care home of those convicted of crimes against the elderly or disabled. And those are the 8 sections of the law, Mr. Chairman, that are addressed in House Bill 72. I'd be happy to take any questions if you wish to
Thank you, Mr.
open to
Chairman.
questions.
Any questions for the author of the bill? All right. I don't seem to have any questions, Mr. Chairman. If
Thank
you would,
you.
is there anyone like to speak to HB 72?
Chairman, I'll just submit
to you that we worked hard with the author on this bill. We think it's a good piece of legislation. It closes some gaps that we've discovered since HB 78, and I'd be glad to entertain any specific questions about it.
Okay. Any questions for Mr. Bayhouse? Thank you. Anyone else like to speak to the bill? If you would, state your name, please.
Yes. I'm Vicki Johnson, and I'm the legislative chair of the Georgia Council on Aging. I am a volunteer member of the council, and I'm here today to let you know that the Georgia Council on Aging was involved in the development of this bill, and we are fully supportive of this bill. And in addition to our organization, I can say that there are other aging advocates who are also in support of this: the Alzheimer's Association Georgia chapter, the Alzheimer's State Plan, AARP, the G4A, which is the Association of Area Agencies on Aging throughout Georgia, Georgia's Long-Term Care Ombudsman, the Atlanta Regional Commission Area Agency on Aging, the YWCA of Greater Atlanta, and the Georgia Women's Policy Institute. Thank you for your consideration.
Thank you, Ms. Johnson. Anybody else want to be heard on HB 72? All right. Appropriate time. Anyone?
I'll move to pass House Bill 72 LC 296186.
All right. Have a motion. Have a second. All those in favor of passage of HB 72 signify by saying aye.
Aye.
Any opposed, like sign? All right. Thank you, Mr. Chairman.
Thank you. I'll stay with this. Mr. Chairman.
If you leave, we don't have quorum. Okay.
Then this is a text.
Where you name? Just last name. There you go. Is Jay Powell, is he here? Bert, you want to do yours next? All right, the next bill that we'll hear is going to be HB 196. And Representative Reeves, you can do that from your seat if you'd like, or you can come up front, whichever one. Okay. Give 1 second, let everybody clear out for 1 second. All right, the bill that we're moving on to is HB 196. Representative
Hightower, it pleases the committee. House Bill 196 is a bill that deals with judicial comment. It is a change in OCGA 17-8-57 so that we treat one particular error at trial the same way that we treat the other errors at trial on appeal and review. What this bill does not do is it does not allow a judge to comment on the evidence, but what it does do is it treats the error, if a judge does make a comment, it treats that error the same way that we treat every single other error at trial, and we're going to analyze the harm before we're deciding, or before the higher courts are deciding whether or not to reverse a case. The current law, 17-8-57, any comment creates an automatic reversal, and there's no analysis of whether the comment actually had any sort of harm or impact on the trial or the outcome, and this is different from any other error that we deal with. If a judge makes a comment that doesn't really have anything to do with a contested piece of evidence or a contested fact, it is, according to the law, it's supposed to create an automatic reversal, and I think there's a need for this to be balanced under a harm test like any other error. So this bill creates a harm test that's consistent with other areas of Georgia law, and is also consistent with how the United States Supreme Court has ruled with almost every other error at trial, regardless of how egregious with how that's treated on appeal. So House Bill 196, if a judge does comment on a fact that has not been stipulated to in a criminal trial, or if a judge comments on the guilt, then there's really two steps. One, if there's an objection, then the judge can make a curative instruction, or the judge could grant a mistrial. if a curative instruction is given, then that defendant would be able to appeal and raise this as an abuse of discretion or a plain error on appeal. If there is no objection, then it's waived, but can still be. If the defendant can still show on appeal that plain error that affected his or her substantive rights occurred, the issue is still preserved. It can be raised on appeal still. It's the way that the law has been set up, or that this bill has been set up. We all know that arguably every trial, or almost every trial, errors occur, and so there's a judicial economy concerned with how it's decided what cases are reversed. And so my reasoning in doing this is that we need to treat this error just like any other. And I haven't been around here very long, but this bill is supported by the state court judges, superior court judges, the prosecuting attorneys council, and the criminal defense council. And so I don't know how often those groups are all in agreement, but on this one they are.
Thank you. Any questions from the committee? Chairman Atwood?
No, it'd be me.
Okay.
Mr. Reeves, isn't it true this grew out of a case where the trial judge in a statement just inadvertently made a statement about, oh, this case occurred in X county, and because of that there was a reversal, and the appellate court said we really have no choice because of the way the prior statute, or the statute as well as case law, addressed the issue, that just by his making a statement of that being the venue of the case, there had to be a reversal?
That's exactly right. There was a case, thank you, Mr. Chairman, this past fall, the Rouse case decided by the Supreme Court. There was a comment within the first 5 minutes. Voir dire hadn't even started yet. The judge, in his introductory remarks, indicated to the veneer that this is a case that occurred in Muskogee County. And based on that comment, that was applied to this rule in 17857. It was determined to violate that, and so there was a dissent written by Justice Namias, which really broke this down and kind of explained the need to go in a different direction on this rule and to make this area more consistent with every other area with our errors at trial.
Thank you.
Chairman Setzler.
Thank you. I'm going to defer to the gentleman's experience on this. I just this isn't a subject matter that we deal with very often in this committee. I'm just asking a purely honest and open question. Either this isn't a leading question in any way. Is this not? Is someone making a human error in a statement having a sort of a cascading effect? What ability would one still have to make a quote honest error as humans make that wouldn't have an unintended consequence of a case being reversed based on a technicality or something that's not a substantive repeated error where there's a whole line of reasoning that's wrong, but perhaps it's just a wrong statement of fact or something?
Well, the way that this bill is set up is it would allow for the same harm analysis that happens in review of every error trial. And on review, on appeal, issues raised, and the defense has an opportunity to make a case that this error, whatever it may have been, affected their substantive rights, affected the outcome, the cascading impact that you had, that occurred. And so if a higher court made that analysis and found that it did, then what they should do is reverse the case and send it back, and it should be retried. But this type of error deserves to be analyzed and treated for harm. Was it harmful? What we had this past fall was a case where a statement was made that argued that probably I don't think could be shown to have caused any harm, but yet this rule or this law that we have on the books required a certain outcome, a certain reversal. And so it's getting the same analysis of harm that we do every other error that happens in trial. I don't know if I answered your question based on what you asked.
Okay. Appreciate you trying.
I have a question.
Yes.
I understand that you're wanting to make this the same analysis. You want this error treated as all other errors. Is there not a concern that a judge possibly making comment on error should be held to a slightly higher standard because of the effect that it could have on a jury that's viewing him as a person that's supposed to be impartial. Is there any concern there at all?
Well, I think that if the judge made a comment that went to that level, the case is going to get reversed. It's going to, a higher court is going to find harm. Currently, and I don't want to take any more time than necessary here, but here are some examples of errors that happen at trial, the egregiousness of errors that happen at trial where they are analyzed for harm before it's decided to send them back. Improper jury instructions at the sentencing phase of a death penalty case. A confrontation clause violation in a death penalty case. Jury instructions containing erroneous law. Admission, this is critical. Admission into a trial of an illegal or improper confession analyzed for harm before reversal is ordered. Defendant not allowed to cross-examine a witness for witness bias, which is a violation of the confrontation clause. Improper comment on the defendant's right to remain silent at trial, which is a violation of their Fifth Amendment rights. Failure to instruct the jury that the defendant is presumed innocent. Admission of evidence obtained in violation of the Fourth Amendment. These are all errors. And these are serious. I know you know that these are very egregious errors. But we analyze these. These are analyzed by the courts for harm before it's decided to automatically reverse the case and send it back. And so a judge commenting on the evidence certainly could be a very egregious thing. But I would put that in line with these examples of egregious errors, and I think it needs to be treated the same way.
Okay. Representative Hightower, to that point, we discussed that in subcommittee. And looking at this bill, I think there was discussion about the indigent defendant or someone who doesn't have the funds to go and appeal a case. Right now, if there is error, the judge says something improper, they have to appeal to get Court of Appeals to look at this. With his bill here, we actually have an automatic, the judge shall give a curative instruction to a jury. And so in my mind, we actually afford more protection for the average defendant. May not have the resources to file an appeal because they're guaranteed a curative instruction if they make this objection at trial. And then they're not losing anything either. They can still go appeal if they want to disagree with the decision of the judge. But I think this actually adds some more protections for defendants that don't have the ability to go appeal. Any other questions? Representative Trump.
Thank you, Mr. Chairman. To the author, this has not just happened one time. It looks like just based on a quick Lexis search that a month ago,
That's right.
the Supreme Court did the same thing and reversed a case where a judge commented. Is that correct?
That's right. And it was the venue was the issue in that case, which is also the issue in the Rouse case. And again, the purpose of this is not to say that any time a judge makes a comment that he should get a free pass. It's to say, let's look at the harm before we decide. Reverse a case, send it back, state the resources, the victims having to go through a trial again for some incidental comment that didn't have any impact on any actual facts. That's what we're trying to do.
Thank you. Any other questions for the author of the bill? Anybody that wants to comment on this bill? All right. If you'll give us 1 second, we'll grab the chairs. Just give us 1 second. Good job. It was appreciated. Okay. Chairman?
It's not a quorum. Quorum is seven.
Still here? Okay, yeah, well, we are good. All right, actually, we do have quorum now, so at the appropriate time. Move to pass.
Second.
Motion and a second. All those in favor of moving HB 196, signify by saying aye.
Aye.
Any opposed, like sign? All right, good. Thank you. Next bill that we'll take up is going to be HB 375. Representative Powell.
Thank you, Mr. Chairman. To give you a little bit, is this something?
Should be.
Thank you, Mr. Chairman. To give you a little bit of background on this, we've got several situations in the law, specifically dealing with traffic offenses, where a person can plead nolo to a reckless driving, or maybe even to a DUI, or to even driving with a suspended license after it's already been suspended. And if they plead nolo within a 5-year, just one nolo within a 5-year period of time, it does not count as a conviction, and so does not add additional suspension time to their, even if they have a suspended license then. There's one exception to that, and that's in driving with a canceled, suspended, or revoked vehicle registration. And in that case, the statute currently says that a plea of nolo in all situations counts as a conviction, and which automatically results in a suspension of a driver's license. And this was brought to me by a judge in my district who said that, I've had people who, as soon as they realized that they had this problem, went out and paid their tag fees or whatever they needed to do in order to get their registration reinstated, and they come to court and they say, I've complied with the law, I've got it all in place, and I want to plead nolo. And he says, if you plead nolo, you're going to wind up with a suspension. And so his only choice at that stage is either to accept a nolo or a guilty plea, which will result in a suspension, or to dismiss the case, which means it's tantamount to saying, they didn't have a case against you, but that's not the case. They did. But to result in a suspension, especially in an area like in my part of the state where there is no public transportation, if your license is suspended, then, you might as well just, quit your job. And so this is an in-between step that gives courts the ability to accept a nolo plea, see that justice is done, but by the same token have a little bit of mercy in there for the guy who has the driver's license. So that's why I've brought this to you, and I would be happy to answer any questions.
Thank you, Mr. Chairman. Any questions, Chairman, on the bill? All right. Is there anybody like to comment on the bill? All right. Seeing no comments, no questions. Appropriate time, Ian.
Make a motion to pass House Bill 375, LC 296387.
All right. Have a motion. Have a second. All those in favor of moving HB 375 as presented, signify by saying aye. Aye. All those opposed, like sign. All right. Thank you, Mr. Chairman.
Thank you, Mr. Chairman, and thank you, Mr. Strickland.
And I run into this a lot in the two counties that two cities I help prosecute. This is a good bill. Thank you. Or you have 280?
I have one more. Okay. Mr. Chairman, I'd like to suggest that if Representative Reeves, with Chairman of Ways and Means, his going might be a little bit easier in room 132. If you're the chairman of the Ways and Means Committee, you might have an easier go of some of these bills.
All right, we'll move on to HB 280. Representative Reeves.
Is that me?
It is.
Sorry.
It is.
Thank you, Representative Hightower. Made again, Police Committee. House Bill 280. This went to subcommittee yesterday. We had some good testimony. I'll turn this microphone on.
In the back.
There you go.
Okay. It does two things. It's pretty simple. The first thing that it does is it adds.
Hit behind us. Hit behind the mic.
Does it work? Okay. The first thing this bill does is it adds to the list of dangerous sexual offenses. That list is significant because folks who fall under that category register as sex offenders. It adds to that list, if you look at the bill on page 2, line number 52, number 4, trafficking a person for sexual servitude in violation of Code Section 16-5-46. Persons convicted of sexual trafficking, specifically sexual servitude, are currently not required to register as sex offenders. And so due to the nature of the types of criminal conduct that get someone convicted of that offense, we felt that this was a needed change, that they need to register as sex offenders. So this adds that to that list. The second thing that this bill does, which begins on line 74, is it adds a provision to the end of the code section. And this is a clarifying provision that I can talk about. But basically it clarifies that venue is in concurrent counties. If a sex offender moves from one county to the next, our code section 42-1-12 requires actions in both counties. They have to let the county know that they're moving from, and they also have to let the county know that they're moving to. There have been some issues for the last several years, that some of which could be communication issues, some of which is different interpretations of the law as far as who has jurisdiction. I believe that a reading of the law shows that both have jurisdiction because actions are required in each county. However, we've seen confusion at the law enforcement level. Yesterday we had some testimony in subcommittee by the Cobb County Sheriff's Office where they've had issues with other counties, saying that with an argument over who had jurisdiction. And so there's been some issues at the law enforcement level. There's also been some issues at the prosecutorial level as well. Oftentimes, as a defense, somebody charged with failure to register who's moved from one county to the next will raise as a defense that jurisdiction or venue is not proper in one county because they'll say it's only proper in the other. And so that issue has come up. And so this is basically just to clarify that jurisdiction is concurrent, that either county, whether it's, say, a person moves from Cobb County to Cherokee County, charges are proper in Cobb County or Cherokee County for somebody who has violated and not complied with what they have to do as a sex offender in the registry. And so prosecutors, prosecuting attorneys council, as well as the sheriff's organization all agree that the addition of this language will help clarify the problems that they're currently facing with these issues. So that's why we brought this forward. Ask for your favorable consideration.
Okay. Any questions for the author of the bill? Representative, I appreciate you bringing this bill. A lot of folks don't realize we actually do have an issue with these, especially the trafficking of persons for sexual acts, and it's something that we definitely need to address. So I appreciate you bringing this.
Thank you.
Anyone like to comment on this bill? All right. No comment. Appropriate time.
Make a motion to pass.
Second.
All right. Having a motion and a second. All those in favor of passing HB 280 as presented, please signify by saying aye. Aye. All those opposed, like sign. All right. Thank you.
Thank you.
This committee's being easy today. Goodness. Goodness gracious. All right, I believe we're down to our last bill. It's going to be HB 352. All right, Representative Strickland. Fine. Right there.
Thank you, Mr. Chairman. Members of the committee, I bring to you House Bill 352, and I am working on LC 296500S. And this bill addresses misdemeanor discovery. And I know the hour is late, want to keep a quorum, so I won't talk too much about history. But as mentioned in subcommittee yesterday, we have not, as a state, made significant changes to misdemeanor discovery since 1983, the year I was born. And we reformed felony statutes in the 90s. Sorry. It's been a long time since we've addressed this.
Danny, I think we need to
Just a few years ago, we addressed this. We're bringing it back up again. But what I'm trying to do with this bill, and I've worked with the Georgia Solicitor General Association. I have Trey Pipkin, solicitor with Henry County, with me here today to talk as well about this bill. But I've worked with them, and as a defense lawyer, we've tried to keep an open mind and try to get as many of the felony provisions as we can to misdemeanor court. And here's basically the difference right now. Under misdemeanor rules right now, the prosecutor has to give a defendant the charging document, the indictment or accusation, a list of the witnesses that may be called to testify, and statements made by the defendant while in police custody. And the only other thing that the defendant gets automatically are the scientific reports that are going to be used at court by the state. Outside of that, though it's not the practice in the places that I go, that is all that a defendant gets from a prosecutor in misdemeanor cases. Now, on the flip side, the defendant has to give nothing to the prosecution. And so what we're trying to do is codify the practice of the places that I practice in, and the way most people think it is anyway, where both sides are giving a little before we go to trial. And what this will do is in addition to the things that a defendant already gets, if they opt in for this, just like felony discovery, you opt in. If a defendant opts in, they'll get the same things I just mentioned, plus they'll now get guaranteed the police report and also supplemental police report before they go to trial. They'll also get copy of books, papers, documents, photographs, and tangible objects before they go to trial from the state. And they'll be allowed to inspect all audio and videotapes before they go to trial as well. Again, for most of y'all, maybe you say this is how it already is. Well, it's not how it is under the law, and so we're going to codify that and allow the defendant to get all that. On the flip side, the only thing that the defendant has to give up under this bill is a list of witnesses that may testify at trial, and also the notice of the defense of alibi, which rarely comes up in most misdemeanor cases, is more a felony defense. But those are two things the defendant has to give up, in turn getting more expansive discovery from the state. So the idea is to try to make sure, just like most of my practice is civil, and the whole idea is before you get in court, you know what you're getting yourselves into. Maybe you can get a plea deal worked out. Maybe you can get an all-pros versus having a practice where defendants walk into a courtroom not having the whole file from the state, not being completely prepared for trial, and vice versa. A prosecutor is going blind at this a lot of times too if they don't already have this practice, and may get halfway through a trial and see a witness they didn't know anything about. They could have not processed the case, or could have worked out a plea deal if they'd known about that witness. And so I'll walk very briefly through this bill. The first section of the bill deals with a written notice that is required. It's very similar to the language in felony statute. The second section, starting on line 33, includes that the indictment, no matter what, whether they opt in or not, will still be given, or the accusation will still be given to the defendant. That second section there, lines 41 all the way down to line 60, both B and C deal with the list of witnesses that are provided by both sides. And we took language directly from the felony statute as to how we identify witnesses as well. On the next page, starting on line 64, we address the statement the defendant made in custody. We address the police report on down on line 74 through 77, a supplemental report. And the bottom of that page, starting on line 93, we address the scientific reports that will be provided to the defendant. And finally, on the next page, page 4, starting on line 109, we address the documents, the photographs that are provided, and also the audio and visual tapes that are allowed to be viewed as well. And the last section on the bottom of that page deals with the alibi defense. And the very end of this bill, two sections I want to point out. Under 17, 16, 26, we address noncompliance, which is the way it works in felony, in my understanding as well. But the judge could order that discovery be had, could grant continuance, could actually prohibit discovery from evidence even being presented at trial if there's bad faith that's shown as well. There's flexibility there for a trial court to look at that if someone raises the objection at trial. And lastly, the general protection, to make sure we still have this in here codified in our law, is 17-16-27, which says any evidence that is favorable to the defendant, material either to guilt or punishment, no matter what, whether they opt in or not, would still go to the defense. And before I turn it over, if it's appropriate, Representative Hightower, to Mr. Pipkin to address his experience with this, there were two amendments to this draft that I wanted to offer for the committee, and this is in my I've had a lot of conversations, a lot of work on the front end on this bill, and this is in my conversations with prosecutors. I'll tell you the challenge we have with this. The reason there's been a big difference between misdemeanor and felony discovery is you have very, very small offices in the state, in some corners of our state, and some even metro counties where you have very small solicitor or misdemeanor courts, including municipal courts. And so we're trying to make sure we don't have a burden that just there's not the resources right now to meet in some of these courts. And so what I'm going to offer to the committee is in section, I'm looking at the wrong copy. Under section, on page 4, under 17, 16, 24, is to strike at least 10 days prior to trial or at such time as the court orders. And that's beginning on the first line, going to the second line. That provides the flexibility for the smaller courts that I've talked to, and even including Henry County Solicitor's Office, a medium-sized office, to continue the open file policy they have already in place to make sure that it's still offered to a defendant prior to trial. The same thing with the next section, 17, 16, 25, dealing with the alibi. This language has it where a defendant is opting in, yet a prosecution, the way it's currently drafted, has to then offer another notice for the defensive alibi to be raised. So if we make that automatic, if we strike on the first line after the comma, upon the written demand by the prosecuting attorney within 10 days after arraignment or at such time as the court permits, strike that entire part, and then also take the 10-day requirement out on line 120 within 10 days of the demand of the prosecuting attorney, or we just make it 10 days prior to trial. And so we leave that 10 days prior to trial in there. Take out on line 121, whichever is later. And I can review that again in a minute for the committee if you'd like. But I'm trying to make sure that I've tied up all the loose ends. Trying to have uniform law while dealing with different sized courts around our state. And I don't know if you want to take questions first for me, but I would like to introduce Mr. Pipkin as well.
Yeah, but before we get there, though, Ledge Counsel was here. She was trying to keep up with those amendments that we're going to anticipate coming up. Jill, do you have concerns with those amendments?
Yeah, the problem on the alibi is you've got to have the prosecutor stating when, so there's an obligation.
Mm-hmm.
You've taken that out with your amendment.
Well, and we can discuss this, but my thought was when a defendant opts in, at that point, if they're going to have a defensive alibi, that's something that automatically have to give 10 days prior to trial. And so it'd take out the redundancy of having a defendant opt in and then have to get a separate notice from a misdemeanor court, misdemeanor prosecutor, and then have another time period start.
Your sentence structure doesn't work. It would say if the defendant elects to have this article apply, stating the time, date, and place at which the alleged offense was committed.
Mm-hmm. Well, that's how we currently have it, because that second part is the 10-day. And I think we ought to move that line to the end of the sentence regardless, probably. That's how we currently still have it.
I think what she's saying is that if we strike that, structurally the sentence is not sound. So we need to come up with how to revise that amendment.
I think if you say, instead of at line 117 at the comma, if you go to line 118 and just take out the time period,
Mm-hmm.
I think that's what you're trying to do. You're just trying to take out the time period. So it would read, if the defendant elects to have this article apply upon the demand by the prosecuting attorney, stating the time, date, and place at which the alleged offense was committed, the defendant shall serve the notice of alibi.
But that would still have the written demand by the prosecuting attorney, 2 demands in there. I think you are right that line 119 needs to be struck as well. But that's if we're going to, I mean, I was taking out the written demand on line 117 too. And that is, again, looking at some small courts, misdemeanor courts like municipal courts that don't currently issue that written demand and make it automatic. When a defendant opts in, that 10 days prior to trial, they'll provide that notice of alibi defense.
Yes, what could be a concern there too, is as well as that if you have some of these guys that defend themselves, they're not going to ever have notice that they need to make such a demand or have. In other words, if the prosecutor sends that demand to them on their alibi, then they'll know, okay, I need to respond to that. I know that's not. I'm just giving hypothetical.
Yeah, the only thing I say in response to that, this whole code section requires the defendant to opt in to these provisions, and so I mean, I understand what you're saying, but it's going to require someone to have enough knowledge as to the code section. If they're pro se, they still have to look up this code section, opt into this code section, which has these automatic things apply. So the average traffic court, where there's no lawyers a lot of times, and no one is necessarily opting into this wouldn't even apply. Okay.
I think I've got a solution. I'm
Okay.
not sure it's exactly what you want, but
Jill, let's see what your solution is.
if you said, reading on line 117, if the defendant elects to have this article apply when the prosecuting attorney states the time, date, and place at which the alleged offense was committed, the defendant shall serve upon the prosecuting attorney a written notice of alibi. So it's either going to have to be in the accusation with those specifics, or in some kind of, it would be in some other kind of notice. But you'd have to have something positive on the prosecutor's part so that the defendant would know to do something.
And if I may ask the prosecutors in the room, is that something that's automatic in an accusation?
The Representative Hightower's question, or point is, after you've received discovery, you now are on notice of when and where we're accusing you of it. You should then, if you are going to raise alibi, notify us. So that's, I think, what we're after is. So what you need to accomplish is, once discovery is received, then an obligation falls on the defendant to provide this information. Now, how to word that, I trusted you.
Okay, that's a good point.
Because the way it is now is that in the felony realm, you can prove any date or time within the statute of limitations, and the state's never required to prove an exact time.
Mm-hmm.
That's why there's if we want them to claim notice of alibi, we have to file more specificity.
Jill, could you state your solution one more time?
Why don't you would you mind letting the solicitor, and let me play with the language a little bit more? The solicitor that Representative Strickland wanted to have.
Yeah, please.
Thank you. Well, thank you. Appreciate you having us here today. Just by way of introduction, my name is Trey Pipkin. I'm the Solicitor General of Henry County. I've been the solicitor for 3 years now, and before that, I was an assistant district attorney for almost 8 years. So I've done both sides. I've dealt with the felony statute, and I've dealt with the misdemeanor statute. My office is one of the offices that falls in that sort of middle category. I've got myself and 10 assistant solicitors that work for me, so there are 11 of us. We prosecute approximately 21 to 23,000 cases a year. About a third of those are going to be traffic, but the other 2/3 certainly are not. And so, sort of going back on the alibi, that would be roughly 12,000. Maybe not quite that, 10,000 notices that I would need to send out in discovery, which is a great deal more. When I was at the DA's office, again, Henry County has about a mid-size district attorney's office, and we prosecuted about 1,500 cases per year. So we're sending out 1,500 notices in a DA office versus 10,000 in an SG's office, which would make a big deal when you multiply that times ever how many SG's offices are in the state. I think sort of one of the things that Representative Strickland and I talked about, in addition to just the obvious historical sort of perspective that we have not updated misdemeanor discovery since 1983, is this. I think that there is a culture that when we hear the word misdemeanor, we immediately think DUI or we think traffic. And that is certainly a part of our calendar, but if I would invite anybody to come and sit on a trial calendar with me and my folks for a week, the vast, vast, vast majority of an SG's trial calendar is not traffic or DUI. It may be 25%. So 3/4 of that trial calendar is going to be a theft case or a domestic violence case or a simple battery, a bar fight, something like that. I mention all that because of this. There is no difference between how you try a misdemeanor theft case versus a felony theft case. There is zero difference how you try a simple battery case versus an aggravated battery case. It's just the extent of the injury. And my assistants, who are sort of romanced by the idea of felony work, always ask about it. And I tell them, if you can try a simple battery, you can try an aggravated battery. If you can try an aggravated battery, you can try a murder case. It's just, that's all a murder is, an aggravated battery that ended with a death, and you got one less witness to crawfish on you. And you got to put the medical examiner on the stand now, but it is the same work. One takes a day to try, another may take 3 days to try. All that is important because we are working by two different sets of rules. In felony world, you have a criminal that steals Mr. Chairman's lawnmower out of his front yard. He goes in to get a drink of water before he cuts his backyard. And his lawnmower's worth $1,200. And so that's going to come to me, and we're going to try it. Versus Representative Strickland's lawnmower, who may be worth $1,800 that the criminal steals, and now it's going to go to the DA's office. That criminal did not make a conscious decision to steal one lawnmower worth $1,200 and one lawnmower worth $1,800. They didn't do that. They made a decision to steal the lawnmower, and we jurisdictionally put it where it needs to be because of the $1,500 bright line. And so, in our estimation, the rules of the game ought to be very similar, or as similar as we can make them. There are often times that we, as prosecutors in state court, are flying blind. We have no idea what witnesses will be called. Quite frankly, there have been multiple cases where if I had known about a particular witness, I would have null-prossed the case. There are also multiple times when the defense should be forced to sit down with us to say, hey, here's my witnesses, now show me everything you got. I can tell you in Henry County, there's an open file policy. If you're a defense attorney or a defendant and you've got a case pending in Henry County in state court, you walk in the door. You don't need an appointment. You walk in the door and say, I want to see my file. And here it is. We give you everything we've got, everything. And a lot of the medium and larger SG offices do that. Now, I partly do it because I was raised by a district attorney who did it. But I think you'll find that that's very common practice. As Representative Strickland was saying, we're really just codifying what is already sort of normal practice. But there are parts of this state where prosecutors are only giving what is required to be given. And I'm not commenting on their motives. I'm sure it's that they are backlogged, they don't have enough assistance, the county's not giving enough money to hire people, and they just can't do it all. So they do what is required of them. This bill would have very little effect on an office like mine that has an open file policy, except for it would now facilitate better negotiations between myself, my attorneys, and defense attorneys, because they then have to tell me what witnesses they may call for trial. So that's sort of my part. I'd be happy to take any questions you may have.
Well, I want to first commend you for having that type of policy in place. In dealing with this, I can say that I believe that you probably knocked down on a lot of your workload by doing that.
I agree with that.
Because whenever I have cases that I have evaluate myself, it's much easier to show clients or defendants the whole file. When they see everything, those that are saying, well, I didn't do this, when you show them on video they're doing it, it tends to clear the case up pretty quickly.
Right.
So I appreciate you and commend you for having your office perform those things that way.
Thank you.
And it was noted the difference in SG's office and your amount of possible demands on those type cases because your volume dealing with traffic and those type issues is going to be much higher.
Thank you.
So that was a good point to be made. Representative Reese?
Yes, I just wanted to say, Mr. Pipkin, thank you for your work on this. When I was kind of echoing some of the things you said, I started my career at a DA's office, and so that was where I learned. When I left the DA's office and went into private practice, I was surprised. I had no idea that there were different requirements or rules with felonies and misdemeanors, and so I've always felt that we should be working towards trying to have the same set of rules. So I agree wholeheartedly. Thank you.
Thank you. Appreciate that.
Any other further questions for the witness?
Just friendly question. Does this close the loop on making them as much the same as possible, or are there broad differences, other differences that ought to be addressed in the future by the General Assembly?
That's a great question. It does not make them identical. In my opinion, it makes them as close as we can get them without sort of disenfranchising part-time SGs, which would include municipal courts and probate courts, versus full-time SGs. A full-time SG like myself or Barry Morgan in Cobb County or Sherry Boston in DeKalb County or Stephanie Woodard in Hall County, our offices are going to function very, very, very similar to their counterpart district attorney offices in that circuit. Very similar. But when you get down in some of the smaller, more rural areas that have state courts, it's sort of all over the map. You've got part-time prosecutors who are doing their best to sort of comply with what is fair and just and the law at the same time. And the way they're going to run their office is very different than the way I run my office. They just can't function that way. I talked to some of my brethren in South Georgia that are part-time SGs. They don't have an assistant. I mean, they literally do everything. They go to court. I try maybe 10 cases a year now, which is probably pretty high for a full-time SG to do that. And I'm gonna tell you, it sets me back 3 or 4 days to just go in the courtroom for 2 days to do that. So I sort of function like a DA office would function, but a lot of SG offices do not and cannot. The direct answer to your question is yes. I think when Georgia is much larger than it is now, when we have increased in numbers and in size, and there are fewer SG part-time positions out there, and they all become full-time, I think you could see sort of the natural progression of the legislation to go to a mirrored discovery statute that would apply to both felonies and misdemeanors.
Okay. Thank you. Appreciate you being here. I believe we may have found a resolution to the amendment. Is that correct?
I believe so. I think Ms. Travis has come up with some language, and I'll let you listen to this as well and see what you think.
So I'm still on page 4 at line 117, and I'll just read out loud what it would change to say. If the defendant elects to have this article apply, comma, when the prosecuting attorney provides a discovery response that includes the time, date, and place at which the alleged offense was committed, the defendant shall serve upon the prosecuting attorney a written notice of the defendant's intention to offer a defensive alibi, and the rest of the line 122 down would stay the same.
Okay.
So it's just clear that if in the discovery response the prosecutor's clear about time, date, and place, and that could be in an accusation, because that could have been included in the discovery response, then the burden shifts to the defendant to
make a
claim
response.
alibi.
Representative Strickland, does that address your concern?
I think it does, because I believe with the discovery, because I didn't even think about that. You have to something that triggers it in the sense of, I was just thinking that you get the file right away. You may not get the file right away. You may learn late in the case that there's a certain time the alleged offense occurred. So I think we have to have something to trigger it, and that being vague enough where it's in the discovery given, that should be enough to trigger it, I think.
I agree with that. If Danny's here,
they had to leave.
I agree with that. The accusation or indictment specifically would give you everything except for the time, but the police report, which we would now be required to give, would list the time. Yep. So I think that's a great fix. I think that covers us.
Yeah. Okay. All right. Are there any further questions to the author of the bill? All right. At the appropriate time.
Technical amendment. I had spoken to you earlier about a technical amendment on page 3. Has that been addressed already? It still need to be opened up.
Well, whenever we make the motion, the appropriate time for amendment, you can, or you can discuss it.
I just wanted to open this up for as it pleases the chairman.
Please.
I'd spoken to the chair about line 76, inserting all between and supplemental, so that we read copies of the police incident report and all supplemental reports with an S. I'm sharing that to the author of the bill. Is that friendly to your intent?
I believe so. And I'll refer to the prosecuting room too, but I think that's what we intended with the supplemental report, to make sure we had all reports. So it would include.
Yes, I think that does. I think if we're going to do that, which that is certainly the intent, is that if law enforcement drafted a report, that needs to be served to the defense. I would feel more comfortable, because supplemental reports could mean reports by anybody, anywhere, at any time. I would feel more comfortable, since we're saying police incident report, that it says something, and maybe Jill can help us out, but police incident report and all police incident supplemental reports or something like that to make sure that we are clarifying that it is only referring to police reports.
All supplemental police reports?
I would say all supplemental police reports.
Yeah.
Okay. Sounds good.
Just want to discuss that on the appropriate time. Mr. Chairman, I'd like to offer that.
Okay.
So as I'm contemplating this amendment, it would read line 76, copies of the police incident report and all supplemental police reports, comma.
Thank you.
Yes, sir.
I'll support that amendment.
All right. I appreciate everybody being patient and working through this. At the appropriate time, we're good. And Representative Reeves.
And I was going to propose the amendments that Representative Strickland spoke of. The first of which is lines.
We got to make a motion and then get a second. We got to get in proper posture for a minute.
Make a motion to move to pass.
Second. All right. I have a motion and a second on the bill. Are there any amendments?
On the substitute, Mr. Chairman, it's 60, LC 296500S.
That's correct. Any amendments to the substitute? Thank you, Mr. Chairman. On LC 296500S.
Yes, I do have some amendments.
All right.
So.
Thank you.
On page 4, lines 109 and 110 to strike at least 10 days prior to trial or at such time as the court orders. And then the second amendment I have is going to be the I believe we're striking on line 117, starting with upon a written demand by the prosecuting attorney within 10 days after arraignment. If I could defer to Ms. Travis's, I couldn't write that down fast enough. So
I believe Ms. Travis is used to having her amendments read in. Ms. Travis, would you help us there on this amendment?
You would strike upon the written demand by and insert when, keep the prosecuting attorney, strike within 10 days after arraignment or as the court permits, and insert provides a discovery response that includes. On 119, you strike stating. 120, you strike within 10 days of the demand of the prosecuting attorney or 10 days prior to trial, whichever is later or is otherwise ordered by the court, comma. When you do all that, if you want me to read it again, how it would read before.
I think we understand.
Okay.
I think we're going to be okay. Is that your amendment?
yes, it is.
Okay. Any further amendments?
Is all that combined?
That is the combined Reeves amendment. All right.
We call it whatever we want.
Any comments on the Reeves amendment? All right. Any comments on the Reeves amendments? All those in favor of the amendments signify by saying aye.
Aye.
All those opposed, like sign. Any further amendments?
Chairman, I'd like to make a much more modest amendment. The Reeves amendment. Simply by adding on line 76, between and supplemental, the word all. Between the word supplemental and report, the word police, and an S on the end of the report.
All right. We'll call that the Setzler amendment. Any comments on the Setzler amendment? All right. All those in favor of the Setzler amendment signify by saying aye.
Aye.
All those opposed, like sign. All right. All right. I believe we're in the posture now to move on the underlying bill as amended. So now this is the vote on LC 296500S as amended with the Reeves amendment and the Setzler amendment.
As a committee substitute.
As a committee substitute. Thank you, Ms. Travis. All those in favor signify by saying aye.
Aye.
All those opposed, like sign. All right. Thank you. And I believe that's our last bill. Thank y'all for sticking with us, and we're adjourned.